The Alliance for Healthy Governance has been in a process of consultation, initially with the chairman of the Joint Select Committee on Ethical Conduct, Jim Wilkinson, basically requesting that the committee consider transferring this inquiry to the Tasmanian Law Reform Institute. We made a submission to Jim Wilkinson over a week ago now, and requested that this transfer be done. We mentioned that the community are largely unaware of the inquiry being conducted by the Joint Committee, and that there's been a completely inadequate approach by the state government and the committee to the importance of this inquiry. It is an inquiry of state significance. It has equal importance to the inquiry conducted by the Law Reform Institute from 2006 to 2007. What we're looking for is a far more extensive promotion period with this inquiry to be conducted by the Tasmanian Law Reform Institute in the same way that they did for the Bill of Rights. The Law Reform Institute, with the Bill of Rights inquiry, put out an issues paper, and this issues paper was circulated to over 800 individuals and community organisations in Tasmania. Not only did they circulate the issues paper to 800 individuals and community organisations, but they conducted over 66 community consultations to raise some of the issues that were brought up in the issues paper. The Attorney-General at the time, Steve Cons, actually launched the community consultation process for the Bill of Rights in 2006, and also started the distribution of the issues paper and a pamphlet. After the launch of the inquiry, unlike this current ethics inquiry, which has only received public notices in the newspaper like this, in the public notices section, there's been no further information put out to the community at all. And considering that this is the most important inquiry in relation to governance that this state has ever seen, this is a grossly inadequate response both by the Joint Committee and by the government. What we don't want to see is that this process be fast-tracked and that the community be denied the opportunity, or you might say the privilege, of being able to have input into this inquiry. After the launch of the Bill of Rights issues paper, various newspapers ran articles on their project and provided information to people about how they could make submissions. Nobody in the Tasmanian community has been invited to do this or been advised about how they can make submissions to this current ethics inquiry. It begs the question, in fact, as to whether or not the process of this inquiry is being conducted either transparently or ethically, or whether that, several members of the community have suggested that this is going to just be a fast and dirty process. And that is certainly not consistent with what the Premier has said about his commitment to the concepts of democracy and community consultation. We were very disappointed that the Joint Select Committee rejected our applications, even though, at the request of Rick Snell, academic in law at the University of Tasmania, proposed that they make available to applicants some discussion papers by Dr. A.J. Brown from Griffith University. We feel that these discussion papers are completely insufficient. There are a number of discussion papers that we would like to see put up on the Law Reform Institute website to encourage a greater understanding of the issues. We have a couple of those discussion papers over here to let representatives of the media see what sort of things we would like to see up. but I'm sure that there are many people across Australia who have enormous experience in relation to ethical conduct, like Simon Longstaff at the St James Ethics Institute, and also AJ Brown, Dr Brian Martin, and a wide range of people who could inform the public's opinion here and therefore enhance their capacity to put forward submissions that are based on information available for best practice reforms in Australia, so that we're not going to be lagging behind in relation to community understanding of these issues. So, I think that's the basics.
I suppose one of the points about the Law Reform Institute process was that they did very extensive consultations. They had expert legal advice, expert legal research, and it was a transparent, open process, whereas this process that's being considered at the moment really could be just a sham. I mean, it may be that there's good intentions behind it, but it may be that it's just being put up in this way so the task is seen to be done, as opposed to really addressing some of the more fundamental issues. So our feeling is that unless the process is right from the start, then the final outcomes of the review aren't really going to have the transparency and credibility that they need for people to accept them as legitimate.
I've personally been a major supporter of the idea of a full independent commission against corruption from the start, and in commenting on the document that's so far been produced in the paper, the most charitable I could be in relation to it is that it has the appearance of being coy and skirting around the issue, and my stance in relation to it has been and will continue to be that if you're a farmer and you find black pellets on the granary floor, you don't look in just one of the feed bins. And it is my view that if we continue on with the Select Committee as it is, when it's over, the response or the outcome will not be substantial, it will not be representative, and it will leave a glaring need for the whole job to be done again. It's possible, in my view, to establish a fully independent ICAC commissioner in Tasmania and then impart to him the jobs of looking at the other issues of ethics, judicial appointments, police integrity, internal investigations, special investigations and things like that. So it is not that we want some truncated, small-time governance of the issues that are troubling us. We want them opened up, looked at, and a controlling mechanism put in place that's fully appropriate to the occasion.